So this event is dedicated to DUNA, a new legal tool for decentralized organizations. We will try to understand whether or not this might be a great new legal tool for decentralized autonomous organization. We have here, I'm personally the moderator. I'm a LexDAO member. My name is Paolo. I'm a lawyer from Italy. The other panelists are David Kerr, who is a principal at Covary, and also wrote with Miles a great article about DUNA, which has been published in the A16Z website, which you can find in the chat. I just put the link of the article. Then we have Miles Jennings, General Counsel and Head of Decentralization at A16Z. Then we have Jordan Teague, partner at Campbell Teague. And finally, Ramona Tudorancea, founder of Jupiter Block and partner at Ethicsian. I put the LinkedIn profile in the chat, so you can just check if you want. So as I said, we are going to speak about DUNA, which is a new legal tool. DUNA stands for Decentralized Unincorporated Nonprofit Association. Before there was UNA, Unincorporated Nonprofit Association. This is a step further because it's addressed specifically to decentralized autonomous organization. Of course, we are all in crypto. We all like crypto. We all support crypto, and we know that the big issue is decentralization. How it's possible to make compatible the corporate legislations with decentralization. Are two concepts which are not so much easy to make dialogue. And so DUNA is a new legal tool which will absolutely facilitate the creation of new decentralized autonomous organization. I would start with David, and I would ask to David the following question. Can you please explain from your point of view what is DUNA and why you think that DUNA is a valuable legal tool for US-based DAOs, decentralized autonomous organizations? Thanks.
You know, it really kind of depends where you define the line of what a DAO is before you can even start talking about it. I think for the purpose of the DUNA, it's worth kind of putting this in the context of protocol DAOs, that governance tokens have surrounded the project and that there are individuals who have control of those tokens and it gives them voting rights. And I think that's a very commonly held definition. And so for the purposes of this, I think that's what I'm going to utilize. And so what the DUNA does is it provides a US option for wrapping, not the DAO itself, not the protocol itself necessarily. I mean, I think one of the big areas of talking about what's getting wrapped is defining. And you have these governance tokens that are controlled by people that make decisions, and then whatever they control, they have some degree of liability for, depending on jurisdictional analysis where they are. And if it's an income-producing event, there may be some tax ramifications for it. And I think the reality is that a lot of projects have significant US nexus. Now, there's not a requirement for tax that an association formed around economic activity becomes a US entity form. They don't have to become a domestic. A group of US people can be in an organization and elect a foreign form of structure. And that's totally fine. The reality of that situation, though, is how taxation flows through to individuals still kind of tracks with where that individual is from in terms of country and in terms of location. And so where an entity is registered is kind of not the most important part of how it's treated. So if you have a foreign entity form that's not a domestic partnership or domestic corporation or domestic trust, that there's a foreign requirement on the US people within that organization. And so I think one of the risks associated with these entity-less projects and this kind of ambiguous question over what entity form is, if you have significant investment, significant activity, significant membership control that's based in the US, then really wherever your entity form is, those individuals from the US have a US tax problem. And this shouldn't necessarily be a US only viewpoint. The US is just particularly aggressive in assigning its taxation rights to its citizens wherever they are in the world. And that's not necessarily how every other jurisdiction operates. So it's a more exigent US problem because the rules are very difficult for US. And I think if you were to look at most projects kind of with an objective view, it's pretty hard to say a lot of them at this time are not funded through US investment, that there's not significant US activity in those governance tokens. And so there's a taxation problem. And so if one of these DAOs were to have a realizable tax event, like diversifying their treasury and swapping one token for another, that the exchange of property for one for another results in a taxable event. And so that taxable event right now, if there's not an entity form, I think there's some debate over what exactly would happen, but it would track back to the responsibility of the US members to be responsible for reporting that taxation. And the foreign entity may or may not have a US reporting requirement. Well, that reality is not very good because it's not easily to comply with. And so to the degree you don't have any US activity, this is kind of a moot point. So you don't need to worry about US entity forms if you don't have any US activity. But if you pull back the blinders on US activity, I think a lot of projects have significant US activities. And those that do, that operate a protocol, it just kind of makes sense that they would take an entity form capable of meeting their tax requirements. Now, you can do that in a high tax jurisdiction like Switzerland. And you can rely on the treaties of Switzerland to say you're paying tax in Switzerland, and so you've met your obligations to paying tax because you're meeting your Switzerland requirements. And then more or less, it's incumbent on the other jurisdictions to make a determination of whether or not there's any extra tax owed. And the way that that works is because there's no uniform court of international law. It's a collection of tax treaties that were negotiated over the years, or originally primarily around manufacturing concerns. And then the modifications that have come from internet activity and the ability to utilize, activity that doesn't exist in any physical location makes it harder to pin down where it should go. And the reality of that has been a lot of the high taxing jurisdictions have lost a lot of value share to low taxing jurisdictions, because to the degree you can, offshore your activity and avoid triggering any tax obligations, that's obviously a good plan from a tax planning strategy. And there's been some, evolution in that thought. And the reality is, if you can actually get a pure play, a pure idea up on the internet only, then it probably does have the necessary markers to avoid taxation until that turns into value that's passed down in the real world in an actual physical location. And so that's kind of the big picture play. And that's kind of the world we've lived in for a while. So there's all this consideration and consternation on articles of what, entity forms should exist. And there's a tremendous amount of projects around taking alternative jurisdictions to the Caymans, to Switzerland, to the US, and just picking a place and saying this is a good taxing jurisdiction. And it may well be if, the facts support it, but the reality is the facts rarely support it. And a significant amount of projects have US tax. Well, there's a huge risk there, because if you're not meeting your tax requirements and you're getting advice from tax people who are saying, this is probably fine, you can avoid paying tax if you have a Cayman Foundation and all these things, and there's actual US activity, the reality is there's going to come a day where it's very likely that the US members themselves will have a financial reporting obligation they're not meeting. When that day comes, I think, it's not going to be necessary for the IRS to be the group that, drives the train forward. I think you have a really clear litigation risk from those people being in a situation where they weren't given the right information, they weren't given the right advice, the people giving them advice didn't give them good advice or line up with the right entities. And there's just a really big impending risk. And I think what a lot of people like to do is look at the lack of enforcement actions in the IRS and say, well, look, nothing bad has happened. Well, if you're in tax, that doesn't mean as much to you. because one, the commissioner of the IRS only recently changed from being a Trump appointee to a Biden appointee. So I think there's certainly a theory to be made that the IRS may well change its tax posture soon. And two, the IRS works 3 to 5 years in arrears because they're very behind. And we really wouldn't have a good indication of what this activity has done because it's really not made its way through the enforcement regime yet. And so I think when you go back to first principles, you have to accept the fact that there is tremendous risk to US-based projects. I use that kind of in the way that computer programmers use software to just kind of cover a bunch of stuff. Nexus is a very complicated discussion, but used broadly. If you're triggering a US taxing event for the vast majority of your project happen to be US members, you have a very big problem. And one of the ways you can solve that risk, both on the domestic side and internationally, is to utilize a US entity structure capable of paying corporate taxation. There's only 3 US tax forms for domestic entities. You're either a corporate tax structure, you're a pass-through tax structure, or you're a trust. Corporate taxation pays tax at a 21% tax rate, and then also any distributions from that entity are taxed. What this allows is one organization to exist. What the DUNA allows is one organization to exist. And this would be the same for an LLC electing C Corp taxation, an LCA electing C Corp taxation, a corporation. What it allows for is the entity to exist capable of paying corporate tax rate in a location on the revenue producing events that are triggering tax events. Now, it drives that jurisdictional nexus to the US, and so it simplifies the process, and certainly to the degree it's taking it from other jurisdictions, one can argue that's not a particularly fair outcome for the advancement of a fair international tax policy. And that's right. That's the reality is the intersection between international taxing authorities is very complicated. The OECD project around BEPS, the base erosion plan prevention, trying to prevent base erosion, has been working this problem for any number of years. And sometimes I think there's a lot of optimism that we're getting to a place of fair apportionment amongst international activity. And I think sometimes we're in a period like we are now, where the best we can come up with is that you pay taxes somewhere and utilize the treaties that jurisdiction has with other places to figure out what the remainder amount of taxes due is. Well, the U.S. has very favorable tax treaties, and the 21% rate is relatively favorable now that it's no longer 35%. And so for a relatively low lift, projects with taxing obligations that are currently passing through to members that don't have a home, that don't have a way of having tax paid, and have a very real risk on that front, and the consequences of which are dire, would be able to find themselves in a corporate tax structure capable of paying tax easily done by a uniform agency and actually not buying out of risk and not having a tax risk plan, but actually meeting their obligations and being compliant and being good citizens in the world economy by doing what they're supposed to be doing and not creating an environment where blockchain projects are given this kind of wide path that they're somehow going to be able to avoid all the other rules of taxation that affects the citizens of every jurisdiction on the planet with the tax code. And so the DUNA itself was developed not as a novel concept where all this was created out of thin air, as much as I would like to lay claim to having had a brilliant idea. It wasn't. It was a meticulous research exercise of existing legal concepts, application, and then just drilling down on the areas where the dynamics between the technology and the existing law provided areas that lacked clarity. And then from a, kind of a soft skills analysis, kind of an ancillary benefit, the existing UNA, where protections existed, the Uniform Act applied in the US probably was good enough to utilize in relation to solving all of these problems, with the exception is no one had invited us to use it there. And so Wyoming making clear that entities that were DAOs could exist as both an UNA and a DUNA at various parts of the life cycle was a huge confirmation of the theory. And I would say it's a theory like gravity, not a theory like unprovable one. I mean, this is certainty that you don't need to have a specific DAO form to have a DAO law. We've been able to exist in the world with multimedia corporations, telecom giants, mass producers of cars. Every industry has been able to exist under these rules and find a home because entity structuring is not particularly interesting. You don't, regulate through entity structure. You don't put on industry limitations. Even in a quasi-regulated industry, those regulations come in up and downstream issues for how the law is applied. And entity structure should be easy. This makes it pretty easy. And so the reality is, for projects that have a need for paying U.S. tax, that have a need for the liability protections that this brings and the certainty of structure, it provides a workable solution for meeting those obligations.
Okay. Thank you, David. It was really a great explanation about DUNA. So now I will pass the floor to Miles. Miles, as I said, is a general counsel for A16Z, but before that, he's a lawyer, so he's a crypto lawyer. So let me ask you, can you explain, please, from your point of view, as I said, of a crypto lawyer, why DUNA, in your opinion, is a valuable legal tool for DAOs, and why DUNA could be a solution for the well-known SEC position in relation to tokens as securities. So please, thank you.
Sure, yeah, great to be here. So I think, David just gave a pretty significant answer as to the kind of tax analysis, right? And I think really there's three benefits of using a legal entity structure in the US, right? You get legal existence, you have an entity that can pay taxes, and you also get legal limited liability. So I think David's covered the tax point. On the other two, right, I think legal existence is important. We've seen that DAOs that have been sued have failed to show up in court, and as a result of that, they often get default judgments against them. So this is what happened in the Oki DAO case. It's also what would have happened in kind of the Maker DAO case had the patent not been invalidated. And this is a patent infringement claim that was brought against them. And so I think it's our industry is left somewhat defenseless if if the organizations that are made up of token holders are not able to kind of represent themselves in court. And I think that will ultimately just lead to more default judgments against them, and that will set bad precedent that ultimately puts the whole industry at risk. All the tax stuff David just talked about is obviously very important, but I don't think that tax and tax structuring should ever really wag the dog when it comes to legal entity structuring and building businesses. I think legal limited liability is kind of a staple of nearly every business built in the United States. There's a reason for that. Obviously the U.S. is very litigious, and as a result of that, building a business without legal limited liability is fraught with risk. I think right now there are multiple class action lawsuits being brought against DAOs and DAO members, and all of them allege general partnership theory, that the DAO is a general partnership, and that therefore all of the members are liable for the actions of other members. And that's a pretty scary world to be in, given that you don't have any idea who the other members of DAOs are and what they're doing and what kind of activity they're engaging in. So that risk is one that I think is incredibly existential to the whole space. And I think a lot of people don't think that DAOs are should subject themselves to the legal jurisdiction of any kind of jurisdiction. But at the end of the day, that's not how the law works. And if you can be sued by someone in any jurisdiction, and if you haven't formed a legal entity somewhere, what is going to be your argument as to why that's not a proper jurisdiction for people to be suing you in? As a result of that, not forming in a given jurisdiction opens you up to the risk that your attackers are going to pick the jurisdiction that is most favorable to them, and they're going to pick a legal entity structure for you. That is exactly what is happening, right? People are suing DAOs in California, where there is already a Judge Orrick, in the Northern District of California, who has already, in the Oki DAO case, determined that that there was no limited liability with respect to DAO members. So the vector of attack is there. It appears to be pretty clear from my perspective. Plaintiffs' law firms are aware of it. And as a result of that, I think, the risk is increasing, and, the industry can respond in one of two ways. They can either, put their head in the sand and pretend that this isn't happening, or they can try and hide behind the anonymity, that token ownership affords in some cases. That's not, an option for a lot, founders. It's not an option for VCs like us. And so as a result of that, there is really no alternative to pursuing legal entity structures that provide limited liability protection. So I think, generally that is, I think, should be the driving decision for most legal entities or most DAOs, as opposed to, anything relating to tax. And then, from a securities law perspective, I would say, look, up until now, the UNA was a structure that was, potentially available, but I think a lot of people were concerned that it wasn't intended to be used by DAOs. The DUNA solves that. It strictly considers, DAOs using the UNA and provides for very simple conversions between DUNAs and UNAs. And so as a result of that, we now have an option in front of us that provides limited liability protection and a way to pay taxes. DAOs can make their own decisions about whether or not they want to use it, and it's more suitable for some situations and less suitable for others. But in a lot of cases, right, that limited liability protection is going to be proved to be very valuable, particularly if you think that blockchain networks are ultimately going to be the things that underpin kind of a whole new internet, right, in Web3. It's hard to imagine someone kind of operating Twitter without limited liability protection, from my perspective. From a securities law perspective, I think obviously legal entity structures have not really kind of satisfied the needs for the security analysis. Obviously, if token holders if you try to use a corporation, that would be a pretty slam dunk case that the tokens are equity. If you try to use an LLC, LLC interests are often thought to be equity. But if you use a UNA or a DUNA, that analysis doesn't hold. The DUNA kind of, it's not a dispositive kind of factor in the overall analysis of whether or not securities laws apply to the tokens of the DUNA. But it does give you another argument to make in court that anyone that's acquiring the assets were not reasonable in their expectation of profits with respect to the tokens, because the tokens provided them with membership in a nonprofit organization that was also decentralized. There are no managers, there are no officers, there are no directors, there are no fiduciary duties to maximize the profits of token holders. As a result of that, the structure looks the polar opposite of a corporation, and therefore justifies kind of a different treatment of the membership interest as compared to the membership interest in a corporation. So I think, again, it's not a dispositive argument. The kind of, as was made very clear in Judge Value's opinion in the Coinbase matter, right? This is about it's always going to be about economic reality. And so that is what ultimately matters, right? But this provides you with a legal entity structure that doesn't impugn your decentralization, doesn't kind of make your securities argument worse. And I think that there are several reasons why it makes it better. So from all of those perspectives, I think that the structure offers a lot of benefits. There's still some lingering uncertainties that need to be resolved. But it's a significant step forward that affords a lot of protections and kind of can introduce a lot of certainty where there's currently uncertainty.
So thank you very much, Miles, for this explanation. So now I will give the floor to Jordan. So I will ask you, from your point of view of US crypto lawyer as well, so let me say, and Jordan is a member of LexDAO as well. What is your opinion about DUNA as a legal tool for US-based DAOs? And also, if you could also tell us something about what just Miles spoke about, the security law and the SEC problem, if I may use this expression. So thank you.
The Gary Gensler problem, absolutely. Well, I guess I'll take those in order. So as far as DUNA as a structuring option, unfortunately, Miles and David have already kind of covered some of the points that I planned on covering, so I can get through this pretty quickly. So in my practice, I have many different kinds of crypto native organizations come to me looking for advice on different things, including how to organize, how to set up. And I also have organizations come to me that are maybe several years in, who may or may not have thought through things as well as they'd hoped on the front end. And I can tell you from both standpoints, legal structuring and planning is so important. And so from the standpoint of a lawyer that advises clients in the space like that, it's a great thing to have another structuring option. Like Miles already pointed out, with the UkiDAO case, that demonstrates how, if you don't pick a structure, a court's going to pick it for you. And that can be highly problematic, obviously, because you may not know what the court's going to choose for you 2 years from now, and you may not like the answer. And I can't remember for sure. I think this may be from the Binance litigation, but I know recently a court essentially said, look, if you say that you're not subject to the laws of any jurisdiction, well, you're in my courtroom right now and you're before me. So, if you're not subject to any laws, then my jurisdiction is just as good as anyone else's. So same principle applies for jurisdiction too. You better pick a jurisdiction or a court will pick it for you. Now, that's not to say that either of those choices that you make are completely foolproof. Sometimes plaintiffs and regulators will try to do something called pierce the corporate veil, which is to say, that's cute. You think you have this one legal structure, but you really have another one. Sure, that kind of thing happens. But the point, obviously, is to try to do the best you can on the front end to have a really good case for, no, this is our structure. And the way to do that is A, to pick a structure, and then B, to make sure that you follow all the corporate formalities. And so I would say I don't really have any particular criticisms of the DUNA. My criticism is really more of the crypto mindset, which can be kind of YOLOing into anything new. And so my advice would be not so much do you pick a DUNA or do you not? It would be, if you're going to pick a DUNA, what are some things to think about? So one would be to truly follow the roadmap that the DUNA law has set forth, which endeavors to try to guide people in the right direction of not having management that is basically engaging in entrepreneurial or managerial efforts on behalf of token holders. And I'll get to that topic more in a second. Another one would be to really think through the legal engineering of all of the on-chain activity. And again, this applies for any kind of legal structure, not just DUNAs, but thinking of what I can recall from the DUNA statute, a couple of examples would be, make sure that you can fulfill any indemnity obligations that you promise to members of the DUNA or the administrators. Make sure that you think through how you're going to obey any court orders should a judgment be entered against the DUNA. Again, this isn't unique to a DUNA, it's just what we're here talking about today. And I think it can be more complex with a DUNA potentially just because there are 100 plus people, maybe 10,000, maybe 1 million one day, we'll see in the DUNA that have to vote on things and potentially control treasury. So just think through the legal engineering. And yes, it's great to have another structuring option in the toolbox. So I guess one other point on structuring, a common objection is avoid the US. And unfortunately, I tend to fall into that camp. But here's the thing. It doesn't really matter where you incorporate. The US will get you if they want to. And so I wouldn't say avoid a DUNA because you want to avoid the US. You can see plenty of examples where organizations structured off of US shores are dealing with US regulators or dealing with US plaintiffs. So I think it's just kind of a red herring, I guess is what I'm trying to say. So I wouldn't just rule out DUNA just because you're afraid of the US. So on to the question of, the Gary problem. And the uncertain legal climate we have here about securities in the US. So I think as crypto lawyers, what we hope and what we really believe deep down is that one day the concept of sufficient decentralization set forth in the Hinman speech will be codified and become black letter law. It's not the case today, but I think that we have a lot of good reasons and anecdotal evidence to believe that striving for sufficient decentralization is a good thing. And I think that the DUNA tries to provide a roadmap for that to make it easier for projects to structure that way. Again, back to the YOLOing thing, though, I would just not assume that by setting up a DUNA, you will be completely immune from any kind of security scrutiny. And I'll just point briefly to the recent Coinbase opinion where the SEC denied Coinbase's motion for judgment on the pleadings on the claim related to custodial staking. And by the way, I completely disagree with the SEC's analysis here, but the SEC is basically alleging that Coinbase's provision of IT services and servers and all the technical things that are required to stake, that by doing that, they're engaging in entrepreneurial and managerial efforts. That is a very, very low bar for entrepreneurial and managerial efforts. And I truly hope that the truth will win the day in that litigation. And luckily, we have a great industry advocate, Coinbase, going to bat for all of us in that. But just remember that so long as things remain gray and unclear, if that's kind of the standard in the back of everyone's minds, that's a pretty low bar. And so it's hard to say what would and would not constitute managerial and entrepreneurial efforts under that standard. So again, I don't agree with that standard, and I hope that that just gets completely blown out of the water in this litigation, in the next year or two. But Gary is always looking for people in the middle. That's one of the things that he said in one of those speeches he made in the last year. So if Gary wants to go after a project, he'll find a way. But we all know he's not exactly the most good faith regulator. And in fact, some of his people got sanctioned recently. So, just take all of that with a grain of salt. But yeah, again, I guess just in summary, legal structuring is so important. Planning is important. You don't do the planning, someone's going to make these decisions for you. And with securities, it's a gray area. There's only so much we can do, but taking steps to comply with this kind of soft, sufficient decentralization standard, I think are, that's a really important thing for a project to consider.
Okay, so thank you very much, Jordan, for your how you explained to us, and also for speaking about the Gary problem. So now it's to Ramona. Ramona is a European Union lawyer from Romania, but she lives in Cayman, of course, one of the top offshore jurisdiction that also David mentioned. So we all know that Cayman is on the top. She also involved in Prospera, which is a new territory in Honduras for kind of sovereign territory in Honduras for the Decentralized project. So please, Ramona, can you give us your opinion about DUNA, but also tell us from your point of view if there are many, or how many, generally speaking, US crypto projects that escape from the US and so formally relocate in Cayman, but substantially remain US crypto projects. And finally, from your opinion, whether or not this DUNA, how might impact, let's say, the business in Cayman for all the service providers of company structures for US clients. Yes, thank you.
Thank you, Paolo. So first of all, just a small clarity. Prospera is a special economic zone in Honduras. It's not specialized in decentralized organizations, but it is a very novel, polycentric.
Sorry for not being.
That's totally okay. I just wanted to clarify that. So from my perspective, we've been following very, very closely these projects, and they're still experiments right now, right? It's like most DAOs would not remain in the current shape and form. I welcomed the Wyoming DUNA innovation because it opens the door to other innovations and more work. It pushes forward the discourse and the advancements in this field. From my personal experience, we do have projects that initiate from the US. But we need to nuance that approach, right? Because most blockchain projects are really transnational. They may have developers in the US or founders in the US, and that's a very important point to take into consideration for tax structuring and implications. But their goal is to be transnational. Their goal is to reach worldwide, right? So from that perspective, choosing an entity in the U.S. that pays tax in the U.S. sort of limits their attractiveness for people outside the U.S., right? Who would say that why should a chunk of the assets of the community, right, that have been like the value has been grown by efforts of the community worldwide, why should a certain territory tax that? And this is why a lot of the projects come to Cayman, among other reasons, right? Like having a non-U.S. issuer, for example, or having the foundation company structure, which is a very, very, bespoke corporate governance solution that is available to them and which can be tailored to the way of functioning and still have the solidity of a recognized, international offshore center. So there are complex motivations that need to be taken into account in the choice of jurisdiction. And frankly, I have to say that most DAOs would do well to have a constellation of legal entities, very bespoke for their purposes, because we cannot start selling people legal wrappers as like cookie cutter approaches, because it doesn't fit them. And then beyond this, I think that it will I welcome this development because, frankly, I'm lobbying for a DAO incubator in Cayman. I'm lobbying for more sort of innovative approaches, growing expertise, growing expert, providing additional value beyond just the incorporation. Because I think we're past the point where the incorporation matters. And then finally, one last mention about why Cayman is actually still a very good solution, and I would like for projects that want to expand beyond the U.S. I would frankly recommend it in many cases. Is that it's a transparency issue. If huge investment funds, right, it's like the big names can use Cayman, why cannot the startups or the DAOs or the innovators, right? It's like it should be open for all. Because it's really, we need to move beyond jurisdictions and like segmenting the world in smaller chunks.
Yeah, but I mean,
yeah, please.
The Cayman entity structure doesn't provide legal limited liability to DAO members. So I guess my question is here's a DAO that has nothing to do with the U.S., Lido DAO, right? There's a class action lawsuit in California. We've been named in that lawsuit. Paradigm's been named in that lawsuit. Other investors have been named in that lawsuit. The founders will eventually be named in that lawsuit. So I guess my question to people on the limited liability front is, how many cases do we need to see DAOs lose and in the United States and liability being apportioned to the members of those DAOs before we ultimately come to the conclusion that those structures are not viable for DAOs?
No, and that's a very good point, Miles. It's a really critical point, because I think we're used to looking at corporations and we try to find those patterns everywhere. But DAOs are not really the same type as corporations, because they don't act in the same way. To the extent that a DAO lies in the fully automated category, right? It's much easier to have decentralization, to achieve decentralization. To the extent that the DAO is very participatory and you have a lot of influence of a few core contributors, those people need to have clearly DAOs have participants risk. So I did an inventory, sort of a risk taxonomy for DAOs, and the participant risk is a real risk that the corporations do not have. So we need to think new frameworks. This is why it's like the DUNA, the Wyoming DUNA is a very good development from my perspective, because it can solve some of the gaps that we have, but DAOs have many other things to solve until they eventually will reach the innovation level and the efficiency level that is able to challenge traditional organizations, right?
Sure.
Yeah, Jordan, please.
Oh, sure. Yeah, no, I was just going to jump in and say the tricky thing about looking at precedent we have thus far is that, and I may be wrong about this, but I think it's mostly regulatory. And it's not to say structuring has no impact on regulatory or how agencies approach projects and determine who they should go after. And indeed, they often do just go after the named entity, but occasionally they will go after control persons and folks of that sort. And so I think it would be helpful to see more precedent in the non-regulatory arena too, to see how innovations like this may improve the situation for DAO members, simply because regulatory is kind of its own animal.
I do have some questions actually for David or Miles. Like based on, we know that we currently have a management gap and a strategy gap in DAOs, right? It's like that's a recognized reality. And like the DUNA doesn't have management, right? It doesn't have directors and officers. It just have administrators. But like, what would be the counterweight to those administrators? Like are there any other roles, bespoke roles possible? Like, can we decentralize further in terms of, you know, strategy, risk, and governance, and can it be built in sort of more multifaceted way?
Yeah, I mean, that's the super exciting thing. You know, the administrators is the new name for an old concept, right? Agency law is a fairly fundamental aspect of corporate formation, establishes the relationships, fiduciary duties, baseless activities, and more or less is built on the principle that what you agree to and what you do is what defines your duties and obligations, more so than starting with, you know, wide management discretion, the business judgment rule, and the wide grants of authority that go with being, you know, in the manager or director role. And so really, you know, the hope is that the DUNA is utilized as a flat structure, and more or less the administrators are the physical avatar of the collective decision-making of the organization for the purpose of doing real-world tasks like opening mail. Obviously, if that organization is going to sign a tax return, that's going to be, you know, a relatively difficult ask because there's responsibilities that run both ways. And so I'm working on a template to kind of share how I think that would work and meet all the requirements. And it's an operational testing requirement, both on who can sign a return, reviews being done, the returns ready to be filed, and how, you know, it's very complex and hopefully comfortable. But the reality is, yeah, because the confusing part about the administrator and the confusing part about the Wyoming law is that, you know, and it's kind of the version of control, it didn't define an administrator as a member of the organization. It meant to. I think it's going to get cleaned up in the first round of amendments, kind of cleaning up some of the blocking and tackling cleanup. The distinction between an administrator and an agent is simply an administrator is someone who is an agent who sits inside the organization. And so the counter principle that was kind of developed around was the assumption around kind of limited partnerships and the Uniform Action on Limited Partnerships, where if no one was a manager, then everyone was a manager. And that simply does not work for DAOs and doesn't work for a lot of decentralized structures. And so the kind of the point around that was, to the degree responsibilities are necessary, you're going to have to build up your fiduciary duties and your around what the obligations are. It's a zero start plan. And because it's a zero start plan, you have to build that up through governance proposals. You have to account for that as you utilize it. And the more complex that gets, if you end up in a situation where all you've done is recreated managers through administrative structure, then you've ended up in a structure that has managers and none of the inherent protections of having managers. So it's kind of tapped around, you don't want to build up into this too complexly. You want to stay flat structure and decentralized and simple, and really use this as kind of the human avatars necessary to facilitate the decentralized infrastructure layer that a protocol DAO represents.
Yeah, just to emphasize that point, right? I think the conception of what DAOs are and what they, you know, and what they kind of bring to the space and why they're innovative, I think is there's a lot of different kind of theories on that. I think that generally speaking, right, what we're talking about when we, you know, view this legal wrapper and what it's for is to wrap a public infrastructure. It's a homeowners association for internet infrastructure. If we build large monolithic entities underneath these organizations or within these organizations, then we just end up in the same spot that we have with the current kind of internet and it being controlled by, you know, monolithic corporations. So the whole idea here, right, is to provide a structure that enables this public infrastructure to remain credibly neutral, right? And then businesses can be built on top of that, C corps, what have you. So people that are running clients on top of the Farcaster protocol right, will have their own C corps, will be developing their own apps, will be interfacing with consumers. But we're talking about the infrastructure layer, right, is a very different concept, and one that doesn't require, right, a hierarchy of individuals kind of coordinating activity and developing, building out kind of an organizational structure underneath these DUNAs.
Okay, thank you. So if the panelists have finished to speak or have nothing else to add, I would say we can pass to the public. I know that there are a number of questions.
Yeah. Awesome. So the first one that probably warrants a little bit more discussion than the second question is, we've already had a little bit of conversations around organizing a DAO in the Cayman Islands. Another very popular option is the Marshall Islands DAO LLC. So if you all could speak how the Wyoming DUNA compares to the Marshall Islands DAO LLC.
Look, every entity form in the world compares against each other the same, right? Like, they exist. There's a set of facts that makes you do it as a state-sanctioned entity. In the United States, we use state law, so we have 50 versions. Most countries have one version of law. That's a little easier. But you form an entity in existence. It's pretty boring stuff. The complications that arise around it are, the fact that every jurisdiction in the world does not follow the same set of laws. They don't have the same set of rules. They don't have the same set of inherent tax, jurisdictional decision-making or function. And it's the intersection of activity that meets those baseline structures that defines how all of this works. So I can have a jurisdiction on Mars, and we can use it, and it can be perfect for DAOs. And if no one's on Mars, and they're in the United States, or they're in France, or they're in somewhere with a tax basis, then me saying that the entity structured in Mars, without tying any economic nexus or physical nexus arguments to that, open it up to meeting its real-world tax compliance issues where they exist. And so to the degree the activity of the underlying project has real-world tax obligations from its citizens or its activities across the world, then you need to take the entity form that can meet those. And so if Mars DAO entity wants to take on the obligation of providing the information necessary for all of its individuals to make their tax payments in their home jurisdiction and file whatever necessary forms they need to file in the United States, then that's a compliant method. I would argue that's really hard, but it's a facts and circumstances test depending on what the entity does. Sometimes it's the right tool for the right job, and sometimes it's a prohibitively difficult structure.
Thank you. So the other question simply?
I tried to fit this question in the character limit. Not sure how clearly it comes across, but my question is, if a DAO set up as a DUNA wants to operationally empower core team contributors and to actually do the work that the DAO exists to do, while avoiding any semblance of managerial activity on behalf of token holders, could these core contributors operate essentially as contractors through single member entities? Or does there some kind of conflict between contractors not being able to also be members?
Look, I would combine that into an administrator question, right? And so the question is, can you, by simply calling managerial effort something different, avoid the fiduciary obligations that come with it? And the answer is, well, it depends on what they're having them do. If they're working and they're providing value and driving the direction of the project forward, that can influence token price. You certainly have a centralization problem with securities. If they are making economic activity and driving that forward, you certainly have physical nexus questions. And to the degree you want to wrap them in as an agent, you need to decide what your fiduciary duties are. So the more robust you build around the administrators, the less effective the structure works, because you're taking on the more traditional form of corporate business that everyone always says does not exist. They're not like corporations, but we want to have a board, and we want them to drive activity. We want them to do things. Well, the more you do those things, the less like a decentralized flat organization you are, and you're driven forward by the efforts of others. Now, that just inherits all of the problems in probably a weaker entity form to make those cases. I would say there's certainly not a prohibition on having, committees. I think committees are going to be very important around things like signing the tax returns to demonstrate the effectiveness of review necessary. But I think every single time you empower someone to do a task, you need to ask, are we empowering them to use their decision-making skills, and how broadly? Or are we empowering them to do a specific task that requires real-world operations?
Oh, yeah, no, I can be really quick. And I'm certainly not the DUNA expert, but maybe that makes it interesting for me to try to answer this to see what I've learned. But I think part of the fundamental issue here is like the definition of what is a DAO, right? And I believe David touched on this at the very beginning, that really a true DAO is not much more than a bunch of token holders making some decisions about a protocol. It seems to me, and I think this is kind of what David was getting at, that if there's a lot more going on, then what we might be talking about is not really a true DAO, but something else that maybe needs to be treated differently than that, entity-wise.
What I was going to say is that I think those are both right. I guess what I would say is, like, from a practical perspective, yeah, you don't put all of these people into the DUNA and have them performing services on behalf of the DUNA and having obligations to other DUNA members to kind of drive value. That would you've kind of defeated the purpose of the organization. But like in many examples, right, there will be a DUNA that is made up of the token holders that perhaps controls a treasury, right, and perhaps controls through governance upgrades to a given smart contract protocol, various parameters of that smart contract protocol. And that's kind of the DUNA, right? There will also be within that ecosystem, there will be separate devcos, right, that are building on top of that smart contract protocol infrastructure. So maybe, if this is let's say, decentralized social media protocol, you'll have multiple corporations that are all building applications, and you might have a devco that is also, working on potential upgrades to the overall protocol. They don't owe that kind of obligation to the DUNA. But they can still, build and propose that the DAO or the DUNA adopts that new protocol or the upgraded version of it. So in a lot of ways, right, use of the DUNA doesn't really change what you see with a lot of existing DAOs and how they function in decentralized governance, where you have many different actors in these ecosystems, and all providing value. The point of the managerial efforts and securities laws analysis is not that no one can provide any value to the ecosystem. It's just that you want a lot of redundancy and you want a lot of people developing. So like, Ethereum's a good example. There are how many thousands of developers that are all building on top of Ethereum, right? You also have Ethereum Foundation. Now we wouldn't, there's no governance tokens, whatever, so we wouldn't say use the DUNA, but like those are the types of ecosystems that you want to see. You want to see tons of people providing value, right? And all of that happening organically within the ecosystem outside of the DUNA itself, right? But that's kind of how you would structure those ecosystems, as opposed to having a bunch of contractors contract with the DUNA to provide given types of services. Because as David was saying, and as Jordan just said, right, if you do that, you kind of basically undermine the whole reliance on managerial efforts, because now you're dependent on those people that you've been empowered to drive the value of the ecosystem.
Yeah, Ramona, please.
Thank you, Paolo. I just had a follow-up question specifically for Miles, because this triggered something. Most DAOs have a big treasury, and they're supposed to manage it, maintain it, allocate it properly, right? Like, how would you see this in the DUNA context? Like, how would that happen in the DUNA?
So same way that it happens currently, right? A treasury would be managed by the token holders, and they can choose to do what they want with those tokens. They could allocate it to a foundation that then issues those tokens pursuant to an ecosystem fund or a grant program. They could run the grant program specifically through the DAO itself and award tokens to people that are making contributions. They could do that prospectively, or like Optimism does, they could do it retroactively. So there's really there isn't really a limitation on it. The thing I would, as David would point out, is that the use of those tokens by the DAO, by the DUNA, right, would create potential tax obligations, right, because you are potentially selling property or you're distributing property, and so as a result of that, you have to account from that from a tax perspective. But overall, the management of the treasury would be very similar to how DAOs currently manage their treasuries.
Okay, so I think we finished with this question. So simply, next question.
Thank you, guys. Yeah, really awesome session. And I was wondering about the DUNA. I thought I heard you say, David, that DUNA's are a good way for these groups of people to pay taxes, where I was expecting that these are, since they're nonprofits, that they're not taxed. Could you just clarify, are the DUNAs taxed? If so, how and how much?
Yeah, I mean, any entity form is taxed unless it qualifies for an exclusion of, income, or it's qualified as a 501c on the U.S. side, as a 501c tax exempt entity, right? So you got a list of things that don't count as income, so thus don't trigger tax, and that's a pretty bespoke list. And then you have the 501c rules around, private foundations and public charities contained in the 501c3, mutual benefit organizations in 501c4, trade associations, business associations, the 501c6, social clubs, the 501c7. You got the mortuary providers, right? And it kind of lists out. So nonprofit is simply a matter of the state entity formation laws for the business entities. And so a nonprofit, very generally speaking, is an organization formed, an association formed for the purpose other than the generation of profits to its members. And so, under the common law, it was kind of the counterbalancing principle to general partnerships, were the exact opposite. They were formed for the production of income to their members. Now, significant evolutions in protections around those forms, qualifications. A lot of states run their, nonprofits through 501c3 or 501c4 qualification for extra benefits or complementary tax treatment, liability protections to members. But at the end of the day, if a classic nonprofit, Goodwill Industries, didn't file its exemptions, they'd be paying tax. And so tax exempt and nonprofit are extraordinarily different concepts. And so although one could take a DUNA, this would not be my preferred form to do it, but one could take a DUNA through the requirements for a 501c exemption. It would become tax exempt if it qualified. Now, the reason why I don't really love the 501c rules applied to DAOs the way a lot of people do is just practitioner experience. The requirements around 501c3, 501c4, 501c generally do not specifically state that you have a board of directors in charge of validating all of the requirements for maintaining the status. But if you look at the case law and have worked in the space for a long time, it's very implicit. And so being able to meet those tests without some form of centralized form doing all of the work to maintain that status, it's very unlikely they're able to maintain it. And so it's possible, theoretically possible. You can certainly set up a limited organization that was intended to do that and probably stay, well within the bounds. But in terms of a practical reality, it's just not a particularly viable option. So with the nonprofit, it distinguishes in this particular case, and the DUNA in particular, is a prohibition on distributions to members. And so where that goes against, the general UNA requirements, is UNAs were constructed with the idea that co-ops could be included as UNAs. And in Texas, they often are. Colorado, they often are. And, distributions of profits in that context are appropriate. Now, it's a very nuanced and hard test to figure out why it's allowed for co-ops and not other. But the end takeaway is simply, the DUNA prohibits distributions of profits, and it was formed for a common nonprofit purpose. And that nonprofit purpose is met by simply not treating it like a for-profit organization with the idea of making the members have a pro rata share of the value.
So next question.
Tersh's question is, what are the requirements and risks related to maintaining the nonprofit portion of the UNA and DUNA? And what happens if a court, regulator, or tax authority makes a determination that the entity is for profit?
Yeah, I mean, look, if you have prohibited distributions with the DUNA, what ends up happening is you revert to being an UNA. And so that's a pretty good starting point. You don't immediately lose your protections as, the DUNA and the DUNA as a sub-entity type of the UNA has the same exact protection structure, and the UNA does not prohibit distributions of profits. And so then the question is, would you be able to categorize that as, appropriate co-op, distribution? Probably not. And so if you track it all the way down and you have impermissible payments, you just lose the corporate structure the same way you would in the event that you don't meet the requirements of being a corporate structure. And so, yeah, it could push personal liability down on members because they acted outside of the protections of the structure which they signed up for. And I think this goes to Jordan's point. about, when you form as a structure, meeting the requirements of that structure is a pretty fundamental part of doing it. What I would say is the alternative is doing nothing, is remaining anywhere and putting yourself at those same risks is, equally problematic. So these are, prohibitions on activity that are supposed to be in line with the Web3 community. They're in line with securities law. And so it's all kind of driving in the same direction. So it would be recommended to, follow the constructs of the law.
So next question, please.
Yeah, absolutely. And first of all, I just want to thank LexDAO for putting this all together and all of the panelists. And I caught the tail end of the Farcaster AMA from several weeks ago, and I was actually responding to a comment from cryptotaxguy.eth, and you can check out a link, and I'll post it in the general chat here. But I asked the question, or made the statement, I would hope that a DAO organized as a DUNA would select subchapter T tax treatment to eliminate the corp tax you mentioned. And I'm wondering if anybody here can speak to DAOs, DUNAs, and selecting subchapter T tax treatment.
Sure. Subchapter T tax treatment is the cooperative section existed for the traditional cooperatives, so not the LCAs. If you go back to the history of the corporate form, incorporated entities exist through a decree from the King of England to start monopolistic activity. You carry that through, the invention of wage employees instead of, masters and apprentice, to actually have payroll, to meet insurance requirements, fund exploration, and then you end up in the Milton Friedman. The corporate entity is there to drive profits to shareholders, right? That's the corporate formation of America in a nutshell. The cooperative is basically an incorporated entity form that was established under the same principles. So it's actually one of the incorporated ones, not an unincorporated business association, which is most everything else. And subchapter T is the tax code that was written around co-ops. And, co-ops are hugely important within the American economy from agricultural standpoints, from, any number of purposes, right? And so subchapter T is the incorporated requirement for cooperatives in a certain form. Look, if you can swing the activity of the DUNA into a subchapter T sized hole in the wall, you could probably elect subchapter T treatment. I wouldn't use the DUNA to do it. I think the UNA was designed around being compatible with subchapter T taxation. I think it was co-op focused. The distributions of the DUNA would immediately take away any benefit, but so does any amount of tokenization or investment. And so I think it just speaks to kind of a general lack of understanding of the taxation of co-ops as a general rule from Jason, and that's fine. But, I think some people have filed tax returns and some people haven't. And so theoretically, I think, okay. I think from a practical matter, if you want to be a co-op, then I would file as a co-op and set up the organization around those requirements. It's probably the more strategic way of doing that.
Okay, so next question.
Yeah, sure. Thank you. So once again, I'll start by sharing what I think I know, which is that the UNAs and DUNAs are not and cannot be registered with the state, which also I think would be a benefit. Does that mean you can't do things like open bank accounts or pass KYB with major financial institutions, et cetera? Or are there pathways to do both of those things? Or do we just not know yet?
I think if we look at the extreme example, right, it's always helpful to go to Jamie Dimon in Bank of America, right? Nobody dislikes crypto more than Jamie Dimon, except maybe Elizabeth Warren. Okay. Bank of America has has worked a solution for UNAs to attain bank accounts. And, it's really difficult because UNAs are specifically excluded from the Bank Secrecy Act. And so for the banking requirements, there really is no obligation. And they should be allowed to get bank accounts without meeting a lot of the requirements. Well, Bank of America drew a pretty, I think, fair line in the sand. It's like, great, the DSA doesn't apply, but if you want a bank account, we're going to more or less require you file the rules of having a bank account. And what they solved for UNAs was, yes, if you do some member disclosure and you provide some social security numbers for the individuals who are responsible for the bank account and coordinate that with Bank of America, then you are going to be able to get a bank account for your UNA. That would be the line of thought I would pursue for all activity in getting a bank account. Would be, look, just because the rules don't apply doesn't mean a bank has to give you a bank account. And if you want to have a bank account, then it's probably helpful to disclose a few people who are going to be responsible for it on who they are in the real world. Now, the protection around that being widely disseminated still exists, but I think the bank has a right to require who they are going to be interacting with for financial purposes. And I think that's a fair compromise.
Okay, so next question.
Hey guys, just want to say thank you again to all the panelists. You guys did a fantastic job, so thank you for joining. Paolo, thank you for moderating. My question is a bit of lateral thinking. So after this discussion, it's apparent that, you know, in crypto, when organizations form, they kind of default to calling themselves a DAO. And because of this, DAOs become targets for you know, bad regulation or just regulation in general. Like you said, Gary likes to go for the people in the middle, right? So with all of this said, and given the fact that entity formation doesn't really provide effective solutions to bad regulation or regulation by enforcement, what are some defenses that the community could try to raise alternatively? Like, how can we fight back against this bad regulation or regulation against enforcement?
I can. Oh, go ahead, David.
Mine's a real quick one. I would try to separate any defenses from, you know, the downstream issues facing DAOs from entity form. If we keep entity form balls and strikes and just make it, everyone needs to be able to meet an existing standard somewhere to have some degree of legal entity. I think we can move one of the more tricky sections away from the historical, where it doesn't really belong. Entity structuring is entity structuring. And then I think we just move the conversation around activity to the various sections of the law where it's much more applicable.
So, yeah, first of all, what he said, I was going to say pretty much exactly that thing, which is, you know, I think that could be a whole other conversation for another day. And I think today, you know, we're really just talking about entity structuring, which can't solve all of our problems, particularly the Gary problem. But since you asked, I was going to just say that one of my favorite approaches recently is the community simply fighting back, fire with fire. There's been at least 2 lawsuits filed against the SEC recently, seeking clarity on, you know, what does it mean to operate in good faith, not be offering a securities offering merely by issuing NFTs to purchasers of your bags. I think that's one of the lawsuits out in Texas. There's a creator of physical merchandise who wants to issue NFTs, but doesn't want to do so without regulatory clarity. So I think that's a fantastic tool, and I hope to see the community fight back in that manner even more.
Yeah, and I would love to see someone use a DUNA to do that same thing. So we'll see.
Ramona, please.
Yeah, I just wanted to follow up on that because the Gary problem is like that's a funny way to put it. I sort of used to call it securities paralysis, but it does push away a lot of the projects and forces them to launch outside of the U.S. So this is why most people go to the Cayman Islands or the British Virgin Islands or elsewhere, is like in Asia or in Europe, and then now with I wanted to follow up to ask Paolo a question. It's like, I know he's moderating, but I'm curious about how he sees MiCA coming into this. Is sort of, we see a lot of the movement in Switzerland for foundation companies, but there's a lot of work under the hood in the EU. And then who knows, they may just innovate something.
Yeah, okay, thanks. Well, as you probably know, or everyone knows, so MiCA is only European Union, so basically the 27 member states, so Switzerland is not part of the European Union. Of course, there is, MiCA is this new legal framework in the European Union, which exists, but still there are some uncertainties, because basically in the European Union, we do things very much complicated. Because we are not a state, we are something between a state and a federal state. So we we have basically this MICA, which is a regulation, so it's directly applicable in all 27 member states. But really, the ESMA, which is the European Financial Authority, is competent to issue RTS, which are regulatory technical standards, basically technical guidelines, and really what is MICA is really on these technical standards. They are currently, the ESMA just issued, but is waiting for replies from the community, from whoever wants to reply. So let's say the legal framework is not really clear, totally clear at the moment. I will say in probably 6 months, we will have a clear legal framework. And I would say probably many European projects will not go anymore to Cayman, to BVI, to Panama, rather offshore. But not all, because there are also international transactional projects, as you said. So I would say that probably MICA will give a good solution for many European projects, but still some of them will still
It's no DAO on the horizon, no DAO Act on the horizon.
No, I know someone was telling me, I will not tell the name of this person, but someone who is able to speak with the European Commission was telling me, because I was just speaking to this person about this event, this DUNA event that we are just doing now. So this person was telling me that at the European Commission, they are looking about DUNA as a possible solution for decentralized organization. So they're just, in the European Union, they're trying to understand how to deal with this decentralized problem, because we had the Gary problem. And then for the point of view of regulators, at least in Europe, I would say decentralized organizations are kind of a problem. They don't know how to deal with them. In MICA, there is a rule which says that if a project is totally decentralized, basically it's exempt from any kind of regulation obligation. But then it doesn't, MICA doesn't say what it means, a decentralized project. So it's totally unclear. So I would say that from the point of view of Europe, at least DUNA is a lot of people in the European Commission looking with interest to do
it. Jason Yonker, do you have something else you'd like to ask?
Yeah, we haven't had any discussion yet about the FinCEN's Corporate Transparency Act and Beneficial Ownership Information, BOI, yet. Does anybody want to speak on that relating to DUNAs?
Yeah, the DUNAs aren't required to register with the Secretary of State of Wyoming and therefore not subject to the Corporate Transparency Act. That was David and I have been writing about that for years, and that was one of the primary motivations, also one of the primary motivations of the people in Wyoming who worked on this bill and wanted it approved. They view the government kind of invasions of privacy as a very significant issue, and the DUNA provides a solution to that.
This call, I think, was great. So I would like to thank all the panelists here. Thank you for your time and for really this great debate. And thank you for everyone in this that just came here to this study group event.